Notice, again, we mentioned earlier that public notice of all meetings is required. Generally, notice is given by posting a copy of the notice of principal place of business of the public body, and with the notice must be posted an agenda. The public body is required to put together on a calendar or fiscal year basis a schedule of its regularly scheduled meetings. Okay, so if it's the first Tuesday of each month, there must be a schedule available to the news media. Public bodies that have full-time staff who maintain a website must post notice and minutes on the website. And I think it has to stay up, the notice, for 30 days. Now, smaller bodies that don't either have a website or don't have a full-time staff are not subject to that requirement. We advise public bodies very strenuously that if you think you're going to be taking action, or you want to take action, or you may take action on an item, you better have it on your agenda. In a bona fide emergency, give the best notice you can, and you make sure any news medium gets the same notice you give to the members. Minutes, all public bodies are required to keep minutes of their meetings, whether open or closed to the public. The minutes have to be, include at least the date, time, and place of the meeting. The members of the public body recorded as either present or absent, and a summary of discussion on all matters proposed, deliberated, or decided, and a record of any votes taken. There is a new provision that really should be in here that will be important. It's a requirement that all public bodies provide time for public comment at all meetings. Taping and filming, general rule is, except in cases where sworn testimony is given, the public has a right to video or audio tape or otherwise record public meetings of public bodies, open meetings of public bodies, I should say. And the public body can adopt reasonable rules, but again, they can't be of a nature that would essentially preclude the usefulness of being able to tape. Exceptions. As we indicated earlier, the general rule is public bodies meet openly. There are a number of exceptions. These exceptions are essentially what we call a derogation of the requirement that the public body meet in open, and therefore they're strictly construed, which is a legal term that means essentially that you can't expand the exception to fit something that doesn't fit within it. It either fits cleanly within the exception or it doesn't fit at all. Commonly encountered exceptions, there are a bunch of them we run into. Probably about half of the exceptions are specific to particular types of bodies, such as school boards, student disciplinary cases, things of that sort that aren't general. Some of the general ones, though, the biggest one we probably run into is personnel matters, often referred to as the personnel exception. It's the first exception in the Act. The term personnel doesn't really ever appear there. It's a misnomer. But this allows the public body to close a meeting to discuss hiring, firing, employment, discipline, compensation of specific public employees. Collective negotiating matters, obviously, if you're negotiating with the union's not going to allow the public body to come into its meetings to overhear what their plan is to bargain. This is a quid pro quo. The public can't come in and hear how the public body proposes to bargain with its employees. Vacancies in public office, in a case in which the public body can fill the vacancy. Candidacy can be discussed in a closed meeting. The various qualifications of applicants and the like can be discussed. Quasi-adjudicative matters, a good example of this would be a zoning change. You have an open hearing where everybody comes in and makes their case on zoning. The public body can close the session to actually deliberate whether or not to grant it. Real property, acquisition or setting the sale price for real property. Again, this is market driven. If the buyers know what your bottom line is on selling property, they're not going to offer a whole lot more. You don't want to let the owner of the property know that you'll go as high as $500,000 if you're going to offer $300,000. So, you know, you're going to try to get it for what you can. Litigation. Matters when litigation is either pending, threatened, or more likely than not to happen. There is a procedure for closing meetings. It basically should be done like any other matter before a public body, which is there ought to be a motion, you know, discussion if it's appropriate, and a record vote taken. And only if the members of the public body concur will the public body close the meeting. And there must be a citation to the exception that's being relied upon to close the meeting. Okay, the golden rule. No final action in a closed meeting. No way, no how, as they say. Final action has to be taken in an open meeting. It has to be preceded by sufficient information to allow the public to know what it is you're voting on.